we're made to understand that an application for permission for judicial review brought by the Prime Minister, Andrew Holness, and two other applicants, Imperium Holdings Limited and Positive Media Solutions Limited, make that 3, plus Positive Jamaica Foundation Limited, against Craig Beresford, Kevin Stevenson, and the Integrity Commission, that the application for permission is to be heard this morning in chambers in front of the Honorable Miss Justice Althea Jarrett. Now, this is interesting because the matter of judicial review, as I've said to you before, it's a unique procedure for an administrative claim, meaning one has to, before one gets to even arguing at a hearing for judicial review, one needs to get permission before one can actually go to the full hearing. The rules are set in a way where for permission to be granted, it can actually be done on paper. So a judge need not invite applicant and other parties to a hearing. One can look at the application that has been made and to make a decision on the basis of the strength of the application, whether there is an arguable ground for judicial review and whether that arguable ground has a realistic prospect of success. And there are none of the bars to allowing the application to go through, such as any delay in bringing the application, or there's any alternative remedy that the applicant could pursue instead of coming to the court to seek judicial review. And the court has been, for the most part, looking at applications on paper and granting them, permitting amendment, because they can say the grounds, the basis on which they're sending the applications through, and they can ask for some amendments to be made to the application, and the application can proceed based on the amended orders made by the court. In this case, however, the court ordered the applicant to serve the respondents, in this case Craig Beresford, Kevin Stevenson, the Integrity Commission. And I believe the basis on which this is done is because the court is of the view, and the rules allow it, that it is desirable in the public interest for a hearing to be held. Right? The rules actually say an application for leave to make a claim for judicial review must be considered forthwith by a judge of the court. The judge may give permission without hearing the applicant. In other words, they can consider it on paper. However, if the judge is minded to refuse the application, or the application includes a claim for immediate interim relief, or it appears that a hearing is desirable in the interests of justice, the judge must direct that a hearing be fixed. I'm not in the judge's mind, but I believe that perhaps the most applicable section of this rule is the one where it says it appears that a hearing is desirable in the interests of justice. And the hearing is desirable even though the hearing is not a hearing in public. So the media, they're not allowed inside the chambers, even if the matter is being seated in open court because of space issues. It doesn't mean that this is a public hearing at this stage, but it seems to me to be desirable in the interests of justice. So the court has directed that a hearing is to be fixed, because when I have a look at the multitude of remedies being sought by the Prime Minister and the 3 other applicants against the 3 respondents, and the grounds that have been stated, it's going to be difficult for anybody to say that there's not 1, 2, 3, 4 or more of these bases on which permission should be granted for judicial review of the decisions of the first respondent, second respondent, and the third respondent, they being the Director of Information and Complaints, the Director of Investigation, and the Integrity Commission. So I think it's the interest of justice, as I said, that is the outstanding basis on which the court has ordered the hearing of this application for permission for judicial review. Right? I understand that it is contested. In other words, the respondents have sworn affidavits. I do not know what the affidavits say because I have not seen them. And I do hope that at the appropriate time, we will get a chance to see them and to share them with you, but also to await, after having a read of them, a date fixed by the court after this application for permission for judicial review is had. Yeah, I know that the court's timetable is particularly heavily loaded, but I do hope that this is one of the matters that can be heard very early in the next term, commencing in January, and it can be treated as matters for judicial review or to be treated with it, which is with some urgency. And at that time now, then we'll get a chance for anybody who desires, who can sit in the court, media representatives can then go in, so that we can keep the public properly informed on the various arguments that are advanced by the various sides in the discussion. I do not know whether the Attorney General, or the Office of the Attorney General rather, has been served with these papers, and I think it would be quite good to have the Attorney General's office in it, especially in light of some of the orders sought by the Prime Minister and the other applicants in the matter. Yeah, so we look forward to hearing what comes out of this matter, whether there will be an order for amendment of any of what is sought by the Prime Minister and the other applicants. I see on the paper which the Prime Minister and his team, through their attorneys, filed, that they estimate the length of hearing, if necessary, to be 5 hours. And this is 5 hours now without time. I don't know if time was allotted in this to hearing from the respondents. I don't know how much time has been fixed. I hope it is not something that's going to carry over into a 2-day hearing, because there's no good reason why at this stage, when you're only making an application for permission to apply, for there to be a full hearing of the matter, then to go on to another full hearing if and when permission is actually granted. It's perhaps a grand waste of the court's time for that to be happen, where there's sort of duplicity in the actual hearings, but we'll wait and see. And I do hope that we will have a decision very soon coming from the judge. This particular judge has been recently called to the bench, recently appointed, but on top of that, she was in the Attorney General's chambers and very versed in this area of law. There are several matters on which I have been either involved representing one party or the next. At least 2 matters I can think of. But if you have a read of some of the decisions coming from the court, you will see that when she was an attorney, that she contested many of these matters in the capacity as a member of the Attorney General's chambers. So the principles, I believe, are quite clear, and so it should be easy for a decision to be turned over in the permission for judicial review application which she's hearing. So we look forward to that. Right? I do not know if the Prime Minister will be in court this morning. Be quite fascinating. He should be there, but I do not know. He need not be there. And as I say that, I go back to where I started earlier, because the principle of the rule of law is alive and well in Jamaica. Alive and well because irrespective of the position that one holds, we don't have a bar to prosecution for anything at all against any high office holder. And I think it is something that is to be celebrated. We thank God we don't have a situation like that in Jamaica, or I don't believe we have that. So our Prime Minister, even though in the civil sphere, is expected to be in court today. If he's not there, his attorneys will appropriately represent him until such time as his presence is required. This is the hotline.
Report released by the IC that scrutinizes Holness's financial affairs and questions his compliance with statutory declarations. The report, which spans 171 pages, was tabled in Parliament on September 17, 2024. Holness is seeking judicial review of the IC's investigation and its findings. He claims that the report is flawed and unfairly suggests unethical conduct on his part. Specifically, he aims to invalidate the report, terminate all investigations into his financial dealings, and challenge certain provisions of the Integrity Commission Act, as well as sections of the Corruption Prevention Act that pertain to illicit enrichment. His legal team has outlined approximately 30 points for judicial review. Holness is represented by King's Counsel Georgia Gibson Henlin from Henlin Gibson Henlin Law Firm. On the other side, King's Counsel Michael Hilton represents the Integrity Commission and its officials. The respondents include 2 senior executives from the Commission, Director of Information and Complaints Craig Beresford and Director of Investigations Kevin Stevenson. The matter continues.